I've probably, confession, done more thinking about it since I was asked to be on the panel than I have in a very long time. And in thinking about what to say today, I remembered a case, and obviously I'm not going to talk too specifically other than to say it was a case involving a sex offense. And there were two young men and a young girl involved. And one of the things that was clear after a pretrial hearing, and it was clear that the case was headed to plea bargaining, is that the defense lawyers were concerned about the sex offender registration that would be a consequence of the plea. And ultimately, there was nothing to do for one of the cases. One of the cases led to a bargain away from the crime sex, but the other, not so. And so one person was able to plead and not get a registration offense. The other pleaded and got a registration offense. And it came to my attention several months ago that all the paperwork that we had done in getting the plea and the sentencing, which occurred 6 weeks later, 8 weeks later, we had him register under the wrong alphabet, if you will. He registered under A instead of under B, and so we had to bring him back in years later to get him under the right registration, because one's a 10-year registration and one is a lifetime registration. Thank you. And I believe, honestly, that if the prosecutor in that case could have had it his way, may have been her way, I don't remember, that they probably would not have insisted on registration. But it's an area that is without discretion. The discretion in the prosecutor was what plea to offer. So I'm going to bring this part to a close by saying that there's, from my perspective, certainly on the Superior Court of the District of Columbia, there's little for the judicial officer to do other than perhaps ensure that counsel has talked with her client about consequences of a plea. And then try to make sure that when we do our paperwork that all the I's are dotted and the T's crossed, because it's going to affect that person's life going forward.
I think the first time I ever heard the word collateral consequences was when I was in private practice more than 20 years ago, since I've been a judge for 20 years, doing white-collar criminal defense work, and we were representing defense contractors. And suddenly we realized there was this thing called debarment and suspension. And these companies were willing to spend almost anything in criminal fines in order to avoid being debarred from doing business with the United States government. The collateral consequences were greater than the criminal consequences for them. And then I had a case, and I'll get back to my judicial experience in a minute, and then I had a case representing a liquor company in a southern state, and this company and several of its officers were being prosecuted for the violation of the 1935 Federal Alcohol Administration Act, which was a misdemeanor. And we should have pled, but the general counsel said, it's a matter of principle. So we fought and fought and fought, and when we went into court one day and I made an argument that this statute had 5 elements, and I was confident that the government could never prove 3 of those 5 elements, the U.S. attorney stood up and said, Mr. Friedman's absolutely right, we can't. So go ahead and dismiss it and we'll indict them all for felonies. Well, the general counsel said, it's fine with me, it's a matter of principle. The 2 corporate officers, on the other hand, the word felony and the consequences of never being able to work in that business again were dramatic. As a judge, one of the first things I did was gather all the scripts from all of my new colleagues 20 years ago as to what they say and do at the time they take a plea. And I looked at it the other day. Actually, I looked at it post-Padilla, and again looked at it the other day thinking about this conference. And it hasn't changed. So basically, the only thing that I say and most of my colleagues say about collateral consequences are this. One, I actually say, where were you born? Some people don't like to say, where were you born? And then they say, you know, Prince George's County or Washington, D.C. or North Carolina or whatever. But if they say another country, then I say, if you're not a citizen of the United States, do you understand that the conviction of this offense may result in your deportation, exclusion from the United States, or denial of citizenship under our immigration laws? And then they say, yes, I understand that. And then I say, and I don't say anything more than that, so we maybe want to get into a discussion of whether I should after Padilla. But then I say, do you also understand that the offense to which you're pleading guilty is a felony? And yes. And do you understand that because it's a felony, you may be deprived of certain valuable civil rights, such as the right to vote, the right to serve on a jury, the right to hold on a public office, the right to certain jobs in the public sector, perhaps even certain jobs in the private sector, and the right to possess any kind of a firearm? And they always say yes, and then they're back a year or two later for a firearm charge. But that was facetious. But that's all I say about collateral consequences. And so I suppose the question is, should judges be doing more post-Padilla? And then Judge Rankin mentioned the Sex Offender Rehabilitation Act. And what you probably know is that, I mean, you all know that we get pre-sentence investigation reports from the probation office. What you probably also know is that we get a sentencing script from the probation office, which basically says, Judge, no matter what sentence you decide, here's what you should do. You know, first you impose the sentence, I sentence you to the Bureau of Prisons, period of supervised release, fine, I'm waiving the fine, I'm not waiving the fine, restitution, forfeiture, et cetera, et cetera. But if you're sentencing someone for a sex offender case, there is this huge, long paragraph, and some of it is required by law, that you must impose these additional conditions of supervised release. And registration follows, but you can't live in certain neighborhoods, you can't have certain kinds of jobs, you can't use computers again, and it goes on and on and on and on. And I think sometimes, first of all, by law, they have to be advised that this is likely to be imposed, and when they see the pre-sentence investigation report before sentencing, all of that's included as a potential consequences. But what I always try to do is to sit down with the probation officer and say, explain to me why each of these conditions is there and whether it's required by law or regulation or what, and why it should apply in this case, because a lot of what we get in federal court are people exchanging children of photographs, images of children being sexually assaulted, 2, 3, 4, 5, 6 years old. And every time you exchange that, it's a violation of the law. And no matter, it has to, the sentence depends on how many images you exchange and all sorts of bizarre things, many of which Congress imposed. But the question is, how many of these individuals who plead to that or are convicted of that are potentially dangerous to children, pedophiles, who might actually physically act out or are just addicted to these kind of, addicted is sometimes the right word, to these kinds of images. And so do you really need to impose all of these conditions on someone who is actually unlikely to ever commit a physical offense against a child or not? So, but beyond sex offenders and beyond the immigration consequences, I don't think I do anything about collateral consequences. And that's only at the time of the plea and at the sentencing.
There aren't too many times when we actually have an opportunity to address collateral consequences. We can at sentencing sometimes when someone is eligible for the Youth Act, which would allow them, if convicted under the Youth Act and sentenced under the Youth Act, to actually have their sentence set aside upon completion successfully. There's also some misdemeanor statute that allows in some drug cases for that same type of a collateral consequence, where you can actually have the case dismissed after you finish your conditions of release. So those are places where we can directly make a difference. The other places where collateral consequences are important are in the plea, and I give every single person the immigration comment because I've actually had lawyers object in my early days when I asked where somebody was born, or if they were a citizen, they would argue Fifth Amendment and wouldn't answer. So I just tell everybody now about the immigration consequences. The other places where it comes into play, though, is when someone comes in on a new arrest or someone comes in on a probation violation. That's where you see the effects of the collateral consequence. That's where you see all the young men who've been looking for work, can't get jobs, want to support their families. And so they went back to dealing drugs or something else because that was the only way they could support themselves. So being aware of those kind of consequences helped me in learning to deal with them, try to get them some services, try to get them hooked up with some discipline or a process that will help them to get a job.
So to take, there are a few things that came up in these initial remarks that I'd like to follow up on. I guess the first one is, so we all know that now there's a Sixth Amendment duty of defense lawyers to advise about immigration consequences, and in I believe every state now, at least some kind of court rule, if not policy, I believe law, saying judges have to advise as well, and some of those pre-existed. Padilla, of course. Judge Friedman, you brought up sex offenders. We've heard about that a number of times today. What about duty to advise, either judicial duty or defense counsel duty to advise about sex offender consequences? And I guess I'm asking this, and so maybe it's not fair to ask a panel of judges, because I do see this as the next Supreme Court sort of case on this, in this area.
It is the next because, again, at least in the federal system, but I'm sure it's true in the states too, the penalties and the collateral consequences are so draconian in the way, in some of the earlier panelists in talking about mandatory minimums and talking about Congress passing certain laws because something offends them at the moment. That's what's happened in the federal statutes governing sex offenses. This is one of the areas where Congress has directed the Sentencing Commission to put things into the sentencing guidelines. And so now we're getting a lot of arguments like we used to get about crack cocaine, which is, you know, now after Booker that you have discretion, don't do the 100-to-1 crack to powder ratio. And of course, Congress has now changed it to 18-to-1, but it took a long time coming because it's not it didn't have the benefit of the empirical evidence of the Sentencing Commission, except to the extent it did. The Sentencing Commission disagreed with what Congress directed them to do. The same is true in this area about sex offenders and federal law. There is more, I know we're not here talking about sentencing per se, but there are more variances from the guidelines in federal courts across the country in sex offender statutes than in convictions than in any other kind of thing. And so I think it is the next area that we are going to be told, perhaps by the Supreme Court, that we have to advise people about the consequences from sex offenders. And frankly, that will be a lot easier to do than what Padilla seems to require, because we know something about criminal law, we judges. We don't know anything about immigration law, which is why I think Justice Alito's concurring opinion is the much better opinion in Padilla, because he was very realistic, and Justice Stevens, frankly, was not.
So just to follow up on that, and then I'd like to ask you all the same question, both of you the same question. So just so people have a national landscape picture, there are the states as the issue of whether there's a duty to advise about sex offender registration. That's an issue that's percolating in the states and the circuits, and it's really pretty split. So some states have said there is a duty, and I don't think the Supreme Court's ever going to require judges as a matter of constitutional law, but I do think that state law rules and regulations will follow any duty that's put on defense lawyers to advise, and so they really do go hand in hand. So some states are saying that sex offender registry is outside the scope of a defense lawyer's duty to advise their client, meaning that your client could be pleading guilty to statutory rape, not be told that's going to mean lifetime or 10-year or 20-year, whatever the state law is, sex offender registration, and that's not ineffective assistance of counsel. Other states have held otherwise. Same thing with civil commitment after serving your sentence. So I guess I'd like to hear a little bit more from Judges Rankin and Broderick on the judicial role there.
I think that this may be an area where the District of Columbia local courts may be leading because we have statutory responsibility under the District of Columbia Code insofar as the consequences of immigration. The Padilla case has resulted in the D.C. Code being amended to include a statutory provision requiring judges to give this advice to every person who enters a guilty plea, a Rule 11 plea. And it says in the code that if we don't, that we have to allow the person to withdraw the plea upon application. And regarding sex offender registration and regarding gun offenses, we also have a duty to advise a person at the time of the plea or conviction, if it's after trial, jury or bench trial, of the requirement of registry. I noticed a representative, a high representative of C. Sosa, our Court Services and Offender Supervision Agency here in the audience, Mr. Cedric. He and I were talking briefly about the fact that there's a lot of responsibility on that agency that provides the court those supervision services. And so the person who is entering that plea or who has been convicted will hear of those consequences at the time of the plea, at the time of sentencing, then when they report for supervision to CSOSA, and then CSOSA has, again, if you aren't familiar with the District of Columbia system, that's Court Services and Offender Supervision Agency, created, I believe, in 2001? 1997. At the time, the District of Columbia's system was, and I use quotations for this, federalized, so that our prison system was expunged. That was a joke.
That was funny.
But not really. And we were, and our system of sentencing was replaced with, again, quotations, truth in sentencing. And we have the same sentencing, overall sentencing framework as the federal courts. But I think that, if you can brag about something, I think we can legitimately say that that we might be ahead, or at least equal with some of the states that are more advanced in making sure that individuals understand. Now, that doesn't mean we can do anything about alleviating those consequences, but at least we make sure that the plea is a knowing and intelligent plea, and if the case is a not guilty plea but results in conviction and sentencing, that the people are aware of the responsibilities and the consequences of the conviction.
And I would just echo that and add that I think also that our attorneys, our defense attorneys, are very good about advising their clients on this point. You see a lot of negotiations, particularly on pleas, about trying to find a way to avoid the registrations and finding other charges that would be acceptable to the prosecutor so that they don't have to register. I saw that particularly when I was doing a juvenile calendar, They worked very hard to keep the young people from having to report for the rest of their lives. And they were frequently able to work around it. So I think they're very in tune with it and try very hard to advise their clients.
Well, the Public Defender Service in DC is certainly one of those areas where DC is ahead of the game, so, and particularly in this area. And that is an issue in itself that came up on other panels, but I'll leave that at that. So I want to take you up on your, the sort of, I won't call it a suggestion, but you said the word, about what the judge's role in alleviating or relieving might be. So I shared with the panel, well, I don't know if I actually gave you the law, but I'll just describe it briefly. In Colorado, there's a relatively new, I think, law called relief at sentencing, and it places in the judge's hands the ability to relieve collateral consequences. Now, I take some issue with the way the law is described because it says you can relieve all collateral consequences, and of course a state court judge can't do that. No judge can relieve all collateral consequences because they live in so many different jurisdictions and there are preemption and other issues. But I guess I'd like to know your thoughts on whether you would like to have this power. That's maybe a rhetorical question, but what would you do with it? How would you administer it? And should all judges have the ability to relieve collateral consequences at the time of sentencing?
Or after?
Yes, I should say at or after. I think Colorado has a time period.
I had a rather extended hearing this morning, and I had a very brief opportunity to look at the act. I think it's being sponsored by Senator Rand Paul.
Well, that's the REDEEM Act. If we can put on hold for a minute, I guess I just would like to ask more generally about whether if there was an act that gave you the authority to relieve collateral consequences at or after the time of sentencing.
Once again, the District of Columbia Record Sealing Act 2006 does give the court discretion in categories of cases. We have cases called eligible misdemeanors, ineligible misdemeanors, and eligible felonies and ineligible felonies, and only God knows what that means. But there are several pages of definitions to wade through to try to figure out what it means. But I think that act illustrates the public policy that the District of Columbia government is fostering, and has, quite frankly, for a long time, even before this act. If I can digress for just a few seconds, I presided over a trial just this week where I learned a lot about something called Project Empowerment, which is an organization that has worked for a long time, 14 years now, to assist felons, homeless, and drug addicted, and people in need to get employed. And I think that and it uses local funds, if there is such a thing in the District of Columbia. It uses only local funds. And I think that it's a great illustration of how the city council and mayor of this city has tried for some time now to get involved with trying to alleviate some of these consequences, collateral, if you will, of people who have been convicted and otherwise disenfranchised and left out, to get involved, get their life started, and get going. And once again, I won't go into the trial, but it was interesting to see, because the trial was a whistleblower case. It was about whether or not this program wastes money. And the jury made a loud and clear statement that they didn't think it was a waste of money. And the real issue was, how many chances do you give an individual, for example, who's done 10 years in prison and is coming out and goes through a job training program but doesn't seem to get it the first time, doesn't seem to get it the second time. How many chances do you give a drug-addicted person who you've given drug treatment, that they didn't get it, that they didn't get it, they didn't get it, you know? And so this jury said, we don't think it's a waste of money to give people second, third, fourth chances on a case-by-case basis. If it sounds like this person is a person who we should have some hope for, you know, and I think that that's what the D.C. Record Sealing Act is focused on, giving judges more discretion in determining whether or not a person should have the past in the past.
You're next.
Not necessarily.
Okay.
Mix things up and go to Judge Broderick.
Okay. I think it would be wonderful to have that ability. I don't understand why anybody wouldn't want to just give everybody all the rights that they could have. Anytime I can give the Youth Act, I want to give the Youth Act. I want to set aside those consequences. But I'd want, on the other hand, to have some type of standards that I need to apply to do that, because if you apply it on a case-to-case basis, on the time that you don't apply it, if there's some reason not to, there'd be a lot of questioning, a lot of feeling of unfairness and inequality, and there should be a reason, and there should be some standards. So with some standards, I think it would be great to have that discretion.